following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss Sri Lanka's recent election to the United Nations Commission on International Trade Law, a pivotal step in strengthening its role in global trade law. What does this mean for the country's legal and economic future? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, tonight's topic is something that we saw develop in recent times in the public sphere and the international sphere as well, and that's on UNCITRAL, the United Nations Commission on International Trade Law, and also a little bit on trade law in general. Now, to speak about this topic, we have someone that is not a new face on our programs or on this show specifically, and that is Dr.Prathibha Mahanamahewa. Doctor, thank you very much for taking the time once again to come to our studios and to explain this topic to our audience. A little bit of an introduction on Dr. Mahanamahewa, despite him being on the program, of course. He is a former professor at the University of Technology at the University of Technology in Jamaica, and he's also the founding dean of law at Kotalawala Defence University. So safe to say we're in good hands when it comes to discussing this topic and breaking it down to the nitty-gritties. Before we go into the discussion, here's a little bit of a breakdown on how we're going to approach this topic. First off, we'll be getting into the basics, the general overview on UNCITRAL and what exactly its purpose is. Next, we'll be talking about the current context and also Sri Lanka's position in UNCITRAL. And finally, we'll be talking about what we can expect moving forward with UNCITRAL.
Hello, I'm Ranisha Fernando. I'm an undergraduate at Faculty of Law, University of Colombo. My question is on fundamentals. What are the key features of UNCITRAL?
All right, well, without any further ado, let's get right into the details of this topic. Doctor, once again, thank you very much. We have quite a bit to break down, especially when it comes to the basics of UNCITRAL and why exactly it's significant as well. So if you could start us off in this discussion, Doctor, with explaining to us what exactly the role is of the United Nations Commission on International Trade Law, if you could explain to our audience.
Yeah, I would like to say first, what is UNCITRAL? United Nations Commission on International Trade Law. It was established in 1966. This is a subsidiary body of the General Assembly of the United Nations. Now, before that, there were certain organizations like this that is in Hague, UNIDROIT, a similar one, but it didn't work up much. Now, in the UNCITRAL, United Nations Commission on International Trade Law, what is their mandate? Their mandate is to harmonize and unification of trade laws and which give a one stage for the whole world. Now with the globalization, we know there are several organizations like Chamber of Commerce, World Trade Organization. They also have different policy making matters. But this is where the high influence one, most of these trade laws are significantly important. Specifically, robust cross-border transactions are there. If different laws are there, it is a little bit difficult when dispute resolution system is coming up. Now, whole world, there are 193 UN member countries. Even 193 UN member countries are there. There are only 4 legal systems. One is called civil law legal system. One is called common law legal system. One is called Holy Quran in Gulf region. And USA specifically Anglo-Saxon common law. Now, trading partners are there. If Sri Lanka and UK entering into a trade transaction, that is all governed by common law. If Sri Lanka and Vietnam entering into a trade transaction, they have civil law, we have common law. When you are drafting the trade agreement, it is very, very important, the governing law of the agreement as well as the dispute resolution. In that case, nation faced some problems in the past. So that's why United Nations Commission UNCITRAL tried to harmonize and unify these laws. So they have a mandate. There are 70 members elected. What they do, they draft, and all the time they are best effort to, progressively how this trade could happen. There are certain legal barriers between that. So promote international trade, and also they try to facilitate several trade transactions. And the other one I just want to tell you, when you see United Nations, there are several conventions. Now if you see human rights conventions are in and other conventions, this is a trade. USA, they never sign a human rights convention, but they are a major party for all these conventions because of trade and money. So that's why we have to see some big trade countries are there, small trade countries are there. So we have to put into the same basket, then only it will run. Now domestically there are certain laws. Now for example, Sri Lanka, we have 1869 Sale of Goods Ordinance. It's a very old one. But today we are doing transaction over electronic version, that is called e-commerce. So UNCITRAL gave one of the best e-commerce model of 1996, and what most of the countries, including Sri Lanka, they have introduced laws parallel to that, and then all the countries are combined. So likewise, they are introducing several conventions. We can discuss in more detail. They have one called United Nations Convention for International Sale of Goods. So that is one of the major one, but UK had not ratified that, Sri Lanka has not, and major countries, nearly 80 countries, they have ratified. This is where international sale of goods transactions. Transaction, what is the contract? 101 articles are there, and most of the time they put into one format. So UNCITRAL, what they try to do, they have these arbitration conventions are there, international trade conventions are there, e-commerce convention, different conventions they use, conducive without any problem most of the countries to put into same page or same platform. Then it is easy when they are entering into transactions. So therefore, even UNCITRAL, they may have not signed some countries, but they can be member countries, non-member, and if they are ready to accept private international law, they can go into that. So their mandate is basically harmonize, unified trade laws and put into one, where with the globalization to facilitate transaction as well as dispute resolution process will become very easy. If a trade dispute drags, most of the time what will happen, the relationship fragile, not like criminal cases. So trade law is where, rather than a draconian law, which should facilitate the parties and put into one common platform without delaying this dispute to resolve as early as possible.
So, Doctor, what I'd like to clarify again from what you just mentioned, there is quite a large scope that the UNCITRAL, the Commission, actually has when it comes to governance and also the balancing of powers when it comes to trade law. Is the UNCITRAL something that can be seen as an enforcement body, or are we only going to be seeing it moving forward in the future as well as just a mediator or a facilitator?
Nothing like that. That is not the enforcement. Basically, they want to take all trading nations into one platform and give a unification rules. Then it is very easy. The parties can decide everything. UNCITRAL is not introducing any other thing how the parties should act. But the parties, there are certain common things are there. Now, for example, if you take e-commerce law, or Sri Lanka, we call 2006 Electronic Transaction Act, see the objectives. So the objectives are basically expanded than the UNCITRAL e-commerce model law, which has given recognition of all electronic transaction as well as electronic signature, emails and all these things. So that is a good thing. So we don't have actually much trade transaction than USA and other countries, because most of these website as well as internet websites are there, facilitated USA. But Sri Lanka buyers are there. So when they come into a contract, it is very easy to understand and resolve disputes coming as much as possible. So the question is where they have Asians, then you have European Union countries, and also you have Eastern Europe, West, as well as African countries. So there are regions they do transactions. So if you follow one trade law, if I follow one trade law, how to resolve this as early as possible? That's why they are asking to sign and ratify this convention and make this convention as your domestic law, not to support or not to minimize anything, but to put into a very easy way when it comes to a trade dispute. So UNCITRAL is trying their best to give the maximum. It is not an enforcement body. This is purely voluntary. If you sign a convention, you can make it as that. But if the trading partners are actually entering into this type of transaction, one flat rule is there. So according to that, you can solve those things. And they are not taking anything, but they have the arbitration, international commercial arbitration UNCITRAL rule. Sometimes they put into that. If the parties want, they can make it. So it is not a force. It is not basically influencing or enforcement body, just to facilitate and to promote and basically to protect the parties from unnecessary issues. So this is where it facilitate, it promote international trade transaction, and as much as possible give the countries. So this is where they have a commission when they are drafting these conventions. 70 members are there participating, observation, and internationally we see NGOs are there, INGOs, and the government, they all take part for this UNCITRAL platform.
So it's a process, it's a platform to streamline and to better facilitate all nations that choose to partake in it in order to better equip trade law and also the facilitation of international trade. Doctor, you mentioned previously.
And also one thing, to expedite. Rather than dragging this type of transaction, otherwise when you give it to the legal department of that country, they will go through that. But if you have one unified laws, then it is very easy and also conducive to enter into transaction as much as possible.
Exactly. So basically the expediting and also the streamlining
Absolutely.
of international trade law.
Absolutely.
Previously, Doctor, you mentioned about the model laws and conventions
Yes.
that we can see that UNCITRAL has put forward in order to better facilitate trade law across the globe. If you could walk us through some of the key model laws that we have seen come up over time through UNCITRAL that has specifically benefited, of course, our nation and also globally as well.
UNCITRAL, one of the main convention that is coming up, International Commercial Arbitration Convention, and also International Commercial Mediation Convention. Now let's see, Sri Lanka, we have 1995 Arbitration Act. This 1995 Arbitration Act is the first and foremost in Asia. But we don't have an international arbitration center still. But other countries have grabbed that chance. So therefore, Sri Lanka 1995 Arbitration Act is fully based on United Nations, that is UNCITRAL, International Commercial Arbitration Convention. So that is where any type of arbitration coming up, the investor, he knows these now government also inviting investors to come and invest, but there are other investment agreements are also there. But I am just saying dispute resolution clause. In that dispute resolution clause, any of the dispute or any or all dispute arising out of this agreement must refer to UNCITRAL arbitration rules, then it is very easy. So countries are ready to accept that worldwide body. And also they do a lot of research. And if you go to www.uncitral.org, you can see the world trade as well as how they are going to promote in these type of institutions. So the countries now today ready to accept that. So one of the major one is 1996 e-commerce model law. What it say? It basically give the formation of electronic contracts starting from section 10, offer, acceptance, acknowledgement of receipt. All these put the parties into one. then it is very easy. So it is not a dispute resolution, it is supporting for formation of electronic contracts. And then you have further the internet service provider is liability, all these things are there. And the basic where medium is neutral, you can enter into electronic transaction or a paper transaction, there is no difference. So therefore judges cannot deny this is an electronic signature, you should come up with the ink signature. No, these are recognized. So it is very much facilitating. So given the recognition of electronic documents, electronic messages, electronic signature, everything, government, when you are filing now even plaint as well as answer, affidavits, all these things you can go with electronic filing. So that is where the new trends are coming up. And also in Canada they have Advanced Electronic Signature Act. Sri Lanka, UNCITRAL Electronic Signature Convention as well as e-commerce model law, that is only one. Some countries they have divided, and also it gives much facility and confidence for the parties to enter into that. And you take UNCITRAL, United Nations Convention for International Sale of Goods. Different countries having different domestic law. Let's see, more than 101 countries, they governed by civil law legal system. More than, actually 56 countries are governed by common law legal system. And also Gulf region, they go with Holy Al-Quran. Now, if you take all these things, different legal systems, so now which law governs this contract? Therefore, one flat rule for the whole world, they have introduced United Nations Convention for International Sale of Goods contract. Any country which they ratify and also they absorb into their domestic system. Now, Australia, New Zealand, Canada, they are UNCITRAL International Sale of Goods contracts as well as their Canadian law is one. But Sri Lanka we have not done. So we still go with the old system, but one day we have to absorb and change this sale of goods ordinance, more than 100 years old. But now what you have to do in other countries, let's say UK, our successor, they have already 1994 Supply of Services and Goods Act. We don't have that, but luckily we have the Consumer Affairs Authority Act 2003, which recognized certain type of services also here. And the other one, UNCITRAL, they want to discuss and promote most of the, now future there can be other conventions. Now, you know, AI is coming up, different things. So they do research and see how far and how well we can give the protection of to the seller and the buyer. Most of these are private law as well as private international law legal principles.
We have to actually, you mentioned a very important aspect of how we can see it develop through the future as well. We have to get to that toward the latter part of this program. Yeah. And I want to get into more of the domestic impact that UNCITRAL has in Sri Lanka as well, especially with the recent electing into the commission that we have seen. Before we get into any of these specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this.
I'm Yasara Veerasinghe. I'm an undergraduate from Rajarata University of Sri Lanka. So my question is on international standards. Can Sri Lanka catch up to evolving international trade law benchmarks?
Welcome back to Law, Land and Liberty. We're in conversation with Dr. Prathibha Mahanamahewa. We were talking about UNCITRAL, the United Nations Commission of International Trade Law, and I believe we got a bit of a good basic understanding on why exactly this commission is so essential and what it has done to further streamline, as you mentioned, expedite the process for international trade law across the globe. I want to do a little bit more focus on the domestic aspects and the impact that UNCITRAL has domestically as well. We just saw recently that Sri Lanka was elected for another 6-year term. So how does that exactly translate to our standing, Sri Lanka's standing in the international trade law environment, Doctor?
Now, when you talk about international trade law, most of the time, powerful nations are getting the membership. So, Sri Lanka secured 177 votes and we got the membership. Earlier also, we had a certain few year gap was there. Earlier also, we got the membership. Now, what we are going to do with this membership? It is very important. United Nations Commission on International Trade Law, they introduce model laws, conventions, legal guides, rules, different aspects. So our experts are participating. So we will get a good exposure how we are going to draft these type of maybe a new rule, maybe a new convention. This is a recognition for Sri Lanka. Sri Lanka is not a very powerful economy and not a very powerful trade partner. If you take Argentina, they are very powerful because they earn billions on this. But Sri Lanka only tea, coconut, rubber. Likewise, we have traditional crops. Now, getting the membership, one side we are getting the exposure to the whole world because you are working with other international partners. So they will understand what type of communication you have to do with Sri Lanka, and our members can expose. One side is drafting the model laws, conventions, rules, guides, those things are there. Other than that, you are getting a chance to introduce Sri Lanka as well as how we are going to amend our laws. Rather than amend laws, we need a new Sale of Goods Act which covers services as well as manufacturing goods and supply services. All these things must include. So our experts go there, they will study and they will get a good chance for get that and add to Sri Lanka, and much experience we will get participate in that. One thing is Sri Lanka recognized in United Nations international conventions, as well as the other one, how we are going to change our laws in future, because Sri Lanka economy is going to expand in future, but laws are dragging very in a delay stage. Even these type of litigation should not go to Colombo Commercial High Court or other courts. Why? There is a facilitator. So that facilitation can give non-litigatory process. That is where you call basically arbitration, alternative dispute resolution methods. In that, how we are going to inculcate our system, our culture, that is different. So we are not expecting 100% UNCITRAL convention, black and white letters, or copy to transfer to Sri Lanka, but get some type of understanding. And also how Sri Lanka doing these trading partners with China, UK, USA. Most of the time we are doing our negotiation, but still they are not confident about our trade laws. To get a confidence as well as to promote our products, services and all, one side the law, one side the product, one side the technology. We don't have the technology. So with that combinedly we can come up to a situation where inculcate the new technology and do whatever good for the future.
Doctor, you mentioned that while we don't have to copy and transfer directly and to have it in black and white directly exactly as UNCITRAL has expected it to be, I think that's an important area for us to focus on a little bit. When it comes to the membership that we have acquired now, how exactly can we expect UNCITRAL to reflect on us being elected as a member? And is there any means of positive impact when it comes to getting them our perspective as a nation so that we can see a little bit more leeway or maybe some sort of flexibility or changes for our situation?
That's very good. Now, let's see UNCITRAL. I'll give you an example. United Nations Convention for International Sale of Goods. Civil law countries, common law countries, both they have contributed for this UNCITRAL. So there are principles, legal principles taken from civil law countries. There are legal principles taken from common law countries. UNCITRAL is a mixture of both, not only one side. And also when Sri Lanka participate, our experience is common law. Basically, whatever the acts and those type of judgments are coming to Sri Lanka, we are also strict with the common law. But we have not done much on the civil law countries. That is common law adjudication and civil law is inquisitorial. There are two different systems. But when you are working with one institution with a mix, that Sri Lanka will get exposed to change our laws or even introduce the new law based on this situation. So this is where we are changing our views, we are exchanging our experience, all these things, and Sri Lankans are much prominent and well recognized in other conventions. Law of the Sea Convention, if you see, Sri Lanka, best professors and best experts were there. So likewise, once you get expertise and recognition, our Sri Lankans can get more high positions in WTO, ICC, or even in other well-recognized UN bodies. So I think this is where we have to think, we have to see how well we can contribute drafting new conventions and new models.
Exactly. It's a very important time in Sri Lanka's economy as well for us to have been awarded this, to have been elected to this membership as well. We, of course, previously have had a membership drawing from our past experience as being a member of this commission. Doctor, how can we see Sri Lanka move ahead in UNCITRAL specifically to sidestep any of the hurdles that we may have had previously? As you mentioned, we may not have acted as effectively as we could have as a country, as a member of this commission. What are your thoughts, Doctor?
Yeah, I think basically UNCITRAL membership is not a new thing for Sri Lanka. Even countries can participate as the observe level. So they will give the permission. And sometimes we are in the subcommittees, not in the main committee. But now we are in the main committee, and which will give a great eye-opener for the other countries how we can contribute to future conventions or any additional protocols are coming. So what as Sri Lankans we have to see, giving the membership is not an award. This is where active participation, even as proactive participation should be there. Then our Sri Lankans will get elected for other, other committees are there, other commissions are there. So that's why we have to show it. So the potential outcome should come up with the members, how they contribute to the commission. Rather than sitting, we won't get anything. But active participation means there are debates, there are, pre-sessions, as well as how well we are going to draft this. Now, most of the meetings, sometimes physically you cannot participate, then Zoom and other facilities are there. So this is where after COVID-19, one thing we see, online participation, most of the commission, even United Nations Human Rights Council I have seen, we have participated online rather than going physically there. So that is where our money also save and also we can contribute well. So we must see in future what type of this is not the manufacturing or product or process, this is where we see the law as well as the legal principles, how best we can suit for in future contracts, future transactions, as well as specifically on a dispute resolution. Those are some of the key areas where we have to see.
Doctor, how urgent do you believe we have to put focus on trying to better align our legislature when it comes to, specifically we previously mentioned as well, the Sale of Goods Act, that's quite ancient as you could call it because of just how long it's been around. How essential is it that we have to align it with UNCITRAL and also other modern pieces of legislation that we have seen brought up in an international context?
That's a very good point. Ministry of Foreign Affairs, Ministry of Trade, Ministry of Justice. These three ministries must sit together now. Experts in these three ministries must review all our trade-related laws. Otherwise, one arm may not work. Because when you go for international level, we need the Ministry of Foreign Affairs expertise, and locally we need Ministry of Justice, the line ministry, and the Ministry of Trade. So if these three combine as a network with the Attorney General Department expertise, what you can do, you can see how fast we can change or we can come up with a new trade law based on United Nations Commission for International Sale of Goods, and also how we have to draft it. Until now, after the independence, I have not seen these three ministries. Even they can appoint a parliament subcommittee, and outsiders also can participate as observers. So first thing, you have to see the more than 101 years old, this sale of goods ordinance. It's still an ordinance, it's not an act. So try to put that. So UNCITRAL, you will have 2 or 3 meetings and give a pledge. We are also absorbing these United Nations like 1996 e-commerce model law. We will absorb the UNCITRAL into our system. Then this will this will spread to other countries, and they may, so now side by side, they will see not only the trade laws, they will think the investment also. So in that, we are in par with the international level. With the globalization, we can't, get rid of that. And the self-sufficiency is no more, and we will come to that system very soon.
We have to talk about the international implications as well, and also locally what business communities can also do to contribute, what we individually can do to contribute to better facilitate and foster the modernization of the legal system and also legislature in Sri Lanka. Before we get into the international specifics and more, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Derana and I'm a law student. And my question is, on the current context, what does Sri Lanka's present position in the UNCITRAL mean for its economic stability?
Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Dr. Prathibha Mahanamahewa. We were just talking about international trade law and, of course, the United Nations Commission on International Trade Law, and how significant the membership that we have been awarded is when it comes to the modernization and also the moving forward of our trade law locally as well. There was one area that I couldn't touch on before we get into the international specifics, Doctor, that is relating to how business communities in Sri Lanka locally can actually move this process forward. Maybe there's something that we individually can also do in order to better facilitate the modernization of laws in Sri Lanka. As you mentioned, parliamentary subcommittees can happen and there could be observance from outside parties. So how exactly can we maybe dip our toes into that area, Doctor?
One of the key players should be Chamber of Commerce. Now, you have Chamber of Commerce maybe in Colombo, regional Chamber of Commerce there. So they should come up because they are the people who are in the driving seat. If the law is not supporting, if the law is not up to date or modernized, they face a lot of issues. Because when they want to enter any transaction, the international partner will ask what type of laws we have. Now today, all the backup laws are there. 2022 Personal Data Protection Act is there. 2003 Intellectual Property Rights Act, as well as the non-updated 1896 Sale of Goods Ordinance. Updated 2006 Electronic Transaction Act, basically we call e-commerce. But there are challenges coming with AI. Right? That is another new area we have to see because we don't have any laws at the moment. AI is not accepted in courts also. Now what I want to tell you is the outside. Now outside you have consumer associations are there, National Consumer Association, Chamber of Commerce. As similar organizations, they may start a dialogue now. So Sri Lanka have got the membership. Within the Chamber of Commerce, give proposal to the trade minister as well as foreign ministry as well as the related ministries. Then they will start a debate or discussion. Now, the lawmaker is the parliament. There is a Sri Lanka Law Commission also there. So one of my idea, getting the membership, not only contribute to international UN, but to domestic Sri Lanka Act. So Sri Lanka now a very good time getting this and come up with our change or come with a new law based on UNCITRAL international sale of goods contracts. That is one key aspect, because we are waiting until UK change. UK has not ratified and signed that, but it's a major party. But people are asking why Sri Lanka is not amending or introducing this one. So it is a key point at the moment with the Sri Lanka in new focus. Appoint a committee comprising with the parties I have mentioned earlier.
So we can see that it could be a gateway for us to foster local as well as international trade connections. That leads me to another question, Doctor. Now, regionally, of course, when it comes to trade partnerships across the globe, we see how much of an impact UNCITRAL can have, especially when it comes to mediation. In our region, in the South Asian or the Asia Pacific region, how significant is it the fact that we better adhere to UNCITRAL and also keep our communications with these regional players?
Regional players, my main argument is SAARC. Now India on board, but some other countries are not on board at the moment. So they have not got the membership of not the UNCITRAL conventions. So what we have to do in the SAARC level, India is dominating. But if you have a very strong law and a dispute resolution method, you may incorporate that into the contract. So the Asian level and SAARC level, these are all regional agreements. So once you come into that system, it's very easy for you to enter into a transaction with African countries. So the African countries, now if you see South Africa and Sri Lanka, our common law, English and Roman Dutch law. And they also have that system. But we are not much connected and working. So if all are working towards UNCITRAL membership and getting and ratify these conventions, we can contribute and expand our economy. The major things, Sri Lanka, enormous natural resources are there, but we don't have the technology, see the phosphate and other things. So once you go and participate these type of discussions, there are sub-discussions, subcommittees are also there. So they will come and understand, they will investigate, they will do a research and how we can get the best. Before that, we must have the law. So that's why I am urging the government to amend this as well as come up with the new Supply of Goods and Services Act, something like that. I mean, not to follow UK, but other countries are also there.
We really have to make sure that we're not falling too behind when it comes to the rest of the nations as well.
At the moment, we are behind the rest of the nation. So getting the UNCITRAL membership
is a step forward.
Is a green light for the country as well as for the ministry. Hey, sit down, look and discuss that. Because we are a member of WTO. So World Trade Organization dispute settlement understanding system is there. We are working hardly. But the only thing, the law, that is all sale of goods ordinance. Now, at least within 6 months, if they can draft it and present to Parliament and pass, then it will be another significant way forward for Sri Lanka.
All right, Doctor, so we are closing in on the end of this program as well, but there's an essential question, of course, with the emergence of new technology that we have seen across the globe and also how it has impacted Sri Lanka locally. How can we expect Sri Lanka's legal system to move forward now with the election of to the membership of UNCITRAL as well? How can we better utilize these key areas of technology development as well as international recognition to better foster trade in Sri Lanka and also abroad?
Very good question. Now let's see, there is a real threat from machine learning, AI. which has made a big impact, not only for trade and for other things like advertisement. So in future, we must see what type of laws we need. At the moment, we have laws, but those are not sufficient to cover this area. So they have to understand worldwide, you have to see how AI threat, how we are going to combat in future, which is must, and see machine learning system to protect the copyright also. All these things are in the research stage at the moment. So I don't know immediately a law can be passed to combat that, but you can control two systems using the technology as well as the law. For that, you must come up with a strong discussion. Even USA also, they have omnibus laws as well as the self-regulation. So system like that we have to develop. But we are a unitary country. In the unity country, how we are going to see it? So that's why we need, in AI, can change anything. So that still not covered under Sri Lanka legal system. So those threats you have to minimize and see how other countries are get rid of those things in their system, and whether they are recognizing or not. It's very hard sometimes. It will make a big impact for this. So getting the we won the election, getting a seat UNCITRAL. Now it's a time to look and do research and see comparatively how other countries are making a big effect for that. So that is one of the best thing we have to see it. And the other thing, start with the regional level and see the major trade partners, discuss with them and try to promote our products, try to promote our IT sector like India, how they have done. So all these things, finally, if the rights are violated of the seller and buyer, the one and only solution or relief coming up with this law. So this old law, Sale of Goods Ordinance, will not give an answer for many things where we have to faster, we have to see emerging technology, how we are going to incorporate to this type of laws.
Exactly, Doctor. And finally, unfortunately, we are running out of time for this discussion. What do you identify as one of the biggest practical obstacles that we can see when it comes to aligning Sri Lanka's laws with UNCITRAL regulations? And also, if there is, to add on to that question, if there's anything that individuals in Sri Lanka can do to better identify and to better move this process along?
Yeah. Number one, we need the political will. How we are now at the moment there is a stable parliament. This is a very good opportunity. This is a golden opportunity. Get this opportunity and first thing, ratify these conventions. There are certain conventions introduced by UNCITRAL we have not ratified. After ratifying, as fast track procedure we have to put it into change the laws. And also which will, when General Assembly, our President go and address and meet all these trade partners, and then you can lobby this. How Sri Lanka very recently has changed these type of laws. So number two, you need a strong research capacity officers of Sri Lanka ministries to look and to get all these things into the Sri Lanka legal system. And number three, where I see, this is where promoting our trade partners, as a lot of tourists are coming to Sri Lanka. Once they come, they will have their own system, but 1 or 2 times we can show how the regulations, laws, which are highly international standards. In that, confidence, trust, create. That is the business.
I think that's a perfect area for us to unfortunately end off our discussion on. There is hope for Sri Lanka, especially with the membership that we have been awarded. And this is a golden opportunity, as you mentioned, Doctor, for us to move forward and to better seem appealing to the international market as well, especially when it comes to international trade and tourism. Thank you very much, Doctor, for taking the time to explain this topic to us today.
Thank you.
All right, well, we leave you tonight with the words of former Minister of Foreign Affairs of Sweden, Anna Lindh. Developing countries must be able to reap the benefits of international trade. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/Derana English. Thank you very much for watching. Have a good night.